They convicted Marcus Webb of murder in 1998. Then an appellate investigator found a certified mail receipt, proof the state's own forensic expert had signed for his subpoena, at a confirmed home address, 11 days before trial. So why did the prosecution tell the jury he was impossible to locate? The case against Marcus Webb was built on blood. His business partner, Raymond Collier, was found dead in the back office of their print shop in Bellport, Ohio, on the morning of March 4, 1998. Blunt force trauma, a blood-stained wrench recovered from a dumpster 2 blocks away, and a splatter pattern on the wall behind Collier's desk that a state forensic analyst, a woman named Patricia Ames, testified had been caused by a right-handed attacker standing inside the office door. Webb was right-handed. Webb had been in that office the night before. The jury took 89 minutes, but before the verdict, the defense had hired its own forensic analyst. His name was Dr. Leonard Fitch, 14 years with the Ohio Bureau of Criminal Investigation, retired, then working as an independent consultant out of Columbus. The defense served him a subpoena on February 21st. He never appeared. On the morning of his scheduled testimony, the court was told that Dr. Fitch could not be located. The judge noted it in the record. Defense counsel, scrambling, offered the jury nothing to counter the blood evidence. Webb got life. In 2013, a paralegal working Webb's appeal case found something in a box of photocopied pretrial documents. It was a certified mail tracking slip, United States Postal Service Form 3811, the return receipt. Dr. Leonard Fitch had signed it himself. The signature was dated February 21, 1998, the same day the defense subpoena was issued. The address on the receipt was a Worthington, Ohio address, not a P.O. box, a house. Here is what that slip means inside a courtroom. A signed Form 3811 is legal proof of service. It is also proof of address. Dr. Fitch signed for that subpoena on February 21st. Then, as of February 21st, someone, the defense, the court, or any party with access to the tracking record, knew exactly where Leonard Fitch lived. The defense claimed they lost contact with him after that date. The court record said he was impossible to locate. But those two things cannot both be true if the certified slip existed in the case file. The paralegal pulled the original subpoena file from the clerk's archive. The Form 3811 was not there. It had been photocopied, along with dozens of other pretrial documents, during a routine pre-appeal duplication request 18 months earlier. But in the original physical file, the return receipt was missing. What remained was a gap in the exhibit numbering sequence. Someone had removed a document between when that file was first assembled and when it was formally closed. But the missing receipt wasn't even the strangest part. When Webb's appellate team finally contacted Leonard Fitch in 2013, he was 71 years old, still at the same Worthington address. He told them he had written a report. He had completed his independent analysis of the crime scene photographs before trial and had faxed a draft to the defense firm on February 18th. 3 days before the subpoena was even served. That fax went to the defense firm's main number. In the defense file, there is no record of it arriving. What the appellate team did find, in response to a public records request to the Ohio Attorney General's office, was a copy of that same fax, received at the AG's office on February 19, 1998, 1 day after Fitch sent it to the defense. Fitch's report ran 11 pages. His conclusion was that the blood spatter on the wall behind Collier's desk was inconsistent with a blow struck from the doorway. The angle of deposit, he wrote, and this is a direct quote, indicates a secondary transfer event, not a primary impact. Someone had moved blood onto that wall after the fact. Patricia Ames had testified to a reconstruction that Fitch's analysis directly dismantles. The jury heard Ames. They never heard Fitch. And the state had his report in their possession before the trial began. Marcus Webb has now been incarcerated for 26 years. The Ohio Innocence Project filed for a new evidentiary hearing in 2021. The Attorney General's office has responded to every subsequent inquiry with the same 2 words: no comment. A forensic expert signed for a subpoena completed his analysis, and faxed his findings, and then, somehow, became impossible to locate. The document certifying his address existed in the photocopied record and vanished from the original file. And the report that would have broken the state's blood evidence reconstruction arrived at the prosecution's office before it ever reached the defense. The one question nobody has answered, not in court, not on the record, not to Webb's attorneys, is a simple one. Who received that fax at the Attorney General's office on February 19th? There is a name on the transmission log. It has been redacted in every copy returned by every public records request filed since 2013. That name is still redacted. That case is still closed.